Good evening, everyone. My name is Alexis McCoy. On behalf of Zeta Phi Beta Sorority Incorporated, Kappa Iota Zeta chapter, where the president is Michelle Langham Robinson, Esquire, and the Zeta Amici of East Point, where the president is Connie Lincoln, I welcome you to our first Legal Eagle Day of Service webinar. Before we get started with our very informative evening, allow me to provide you with a little background information before introducing our speaker. Violet Neatley Anderson was the 8th national president of Zeta Phi Beta Sorority Incorporated and the first African-American woman to graduate from law school in Chicago, Illinois. She was also the first woman to engage in a private practice in Chicago in 1920. In 1922, Attorney Anderson became the first African-American woman appointed to the position of assistant prosecutor in Chicago. The purpose of this event is to honor Violet Neatley Anderson, Esquire, and other attorneys throughout the sisterhood of Zeta Phi Beta Sorority Incorporated. So now allow me to introduce our speaker for the evening. First of all, it's a he, not a she. Attorney Keith R. Miles began his career working in the tax field for firms such as Price Waterhouse Coopers, Merrill Lynch, Singular, and AT&T. Later, he shifted his practice focus to the field of estate planning and elder law after the passing of his first wife from pancreatic cancer in 2009. So it's personal experience that has affected him deeply. And now he supports others dealing with difficult legal situations, tax, and financial decisions. Attorney Miles is a sole practitioner with his primary office located in Gwinnett County, Georgia. He also has a virtual office in Charlotte, North Carolina. Attorney Miles currently serves as a treasurer for the Atlanta Bar Association's Elder Law section and is a proud member of the Georgia chapter of the National Academy of Elder Law Attorneys and the Estate Planning Council of North Georgia. Attorney Miles is an active member of the Georgia and North Carolina bars. He was originally a member of the New York bar before resigning. His educational studies is an LLM from the University of Alabama, an MBA from the University of Georgia. He has his Juris Doctorate from the University of Maryland and a Bachelor's of Science from Carnegie Mellon University. At this time, I give you, and it is with great pleasure, that I yield the floor to Attorney Keith R. Miles. Let's welcome him by giving him a virtual hand clap.
Thank you so much, Alexa. I really appreciate it. Thank you for first reaching out with the invitation. It's such an honor to speak to your sorority tonight. So, ladies, I'm definitely very interactive. So we're going to try to field questions as we go through the presentation. So they're going to collect in the chat, and then we have certain stopping points, and I'll address any questions as we go along. So I'm going to start and just kind of looking at the first picture. As Alexis mentioned, I have a original background in tax, and I kind of expanded to estate planning. And when I started with estate planning, it was very much the traditional do a will. People came. I didn't even try to do trust then. It was just more do a will, advance directive, power of attorney. And then I kind of expanded a little bit more into trust. But as I did the work, I realized there was a gap. And so many people plan on having a view when they come in my office of planning for death. But we want to plan for life. And what's the difference? Can you see me?
Yes, we can
The
see you.
slide didn't.
We can see you and the slide.
Which slide is it on? Because it's not moving for
It's
me.
the very first one.
Okay, it's not. Sorry, a little technical. Not seeing it move.
I can try and share it and see if it works there. Give me 1 second.
Okay, now it moved.
Now it's
Okay,
moving.
all right. So elder law is an area that's a little bit newer, probably in the last really 30 years. It's growing more and more as the population ages. We have the issues around aging, and most of the issues around aging are going to be long-term care oriented, but the issues around aging so focus really on the word being vulnerable, and that vulnerability can apply to anyone at any age, whether you are someone who is maybe intellectually disabled from birth. I do a lot of work with brain injury clients. So someone may have been not disabled for a period of time in their life, had an incident, and then the rest of their life, they have a disability. So elder law is trying to address that gap of making sure we don't just focus on planning for what happens when we pass away, because if we don't adequately plan for our lifetime expenses, we may wind up spending down our life savings before we get to those documents that we think will pass on generational wealth. So I wanted to kind of start to illustrate what the difference would be a lot of times with how an elder lawyer would start approaching things versus an estate planner would typically approach something. Also, this kind of, as it starts the education, some people may well be aware of some of these things, some people may not. So in the example, a man named Don, he's single, childless at one point, named his brother as a beneficiary on his IRA and his life insurance. Most of you probably have those forms that you filled out through either employer insurance or private insurance. After his marriage, Don went to the attorney, got a will done to leave everything to his wife. However, Don never changed his beneficiary designations on his IRA and his life insurance. Those items are controlled by those forms. The will only handles what we call probate property. The IRA and life insurance are non-probate property. So they operate by that form, move directly to his brother, bypass his wife, okay? We don't want that kind of mistake happening. So that would be something that most estate planners, even the newer estate planner, would try to make sure that coordination happened. Now the elder lawyer, let's change the scenario just a little bit. Same situation when he was single and childless, he named the brother as the IRA beneficiary and life insurance beneficiary, got married. However, he suffered a stroke. He never got a chance to do a power of attorney. A lot of times what happens, someone will call the office and say, I want to set up an appointment to get power of attorney over, and you can insert whatever family member, mother, father, child, so spouse. You cannot get a power of attorney over someone. Someone has to give you the power of attorney. And many a times when someone's coming to our office, it's often too late for them to actually execute this form. So in this situation, if Don had not done this form and had a stroke to the point where he was incapacitated and couldn't execute one, now that designation can't be changed, okay? The wife does not automatically have authority as spouse to do these changes. So that becomes a situation where we try to talk to people about the necessity of having these in place, because you never know what something like incapacity will happen. We always know death is possible at any time, but people don't really think of incapacity in the same way. Number two, another slight twist. A lot of people don't know that there is a uniform durable power of attorney. Durable power of attorney, just so we're clear, And we're going to talk about this later as we go through the forms and the types that we use. But a durable power of attorney is for financial matters, contract matters. Durable means that it will stay in effect after you become incapacitated. So originally, if you went way back in time, the power of attorney would expire when you lost your capacity or if you passed away. So now it still loses the force when you pass away, but the durable has language, okay, if I lose my capacity, it will still stay in effect. State of Georgia and many other states have followed a uniform act where they have a structure of powers that they like to outline to make it a little clearer for everyone what's being given in the form. A lot of attorneys still like to give their own form, their own format of how they want to give these powers. And it's very hard if you're looking at a form that you haven't looked at before, maybe the attorney's doing something in a special way. It's hard to know exactly what powers are being given. So the state of Georgia and other states have said, okay, if we use a uniform form and general powers will refer to the state code, we'll know exactly what they're giving. So if I says real estate or operation of a business, I can go to the Georgia code and I can see a section listing all the powers out. Now the issue is the way the form is, if you've seen the Georgia power of attorney form, it gives all these categories and at the bottom it says, you can check here to give all the powers above. And a lot of people think that is security. I can just give those general powers. My agent will have all the ability to do whatever he or she needs to do. The problem is that doesn't cover certain situations like this. The legislature is worried durable power of attorneys can obviously handle financial matters, large amounts of money. If you are an agent that doesn't necessarily have the right intentions, you can have powers where you shift someone's estate plan. If I have, for example, general powers to do life insurance, I can call the company up, say, is there a policy? What does it cost to keep it in effect, and arrange to keep it going? So I refer to general powers as maintenance powers. If someone has that, they can function for someone, pay their bills. But the special powers section is a section where someone can do some potential damage or some potential good, depending on the situation. Special powers, I can create a trust for someone. I can do gifting for someone. I can, in this situation, update someone's beneficiary designation. So if I had the special powers, Don, I could have updated the beneficiary IRA, updated the life insurance IRA to the wife. So if the wife had that special powers on her form that were granted, she could update the powers attorney herself. But these designations don't happen without those specific powers. So since he wasn't aware what to give, which I see a lot, when they come to make the appointment, and at that point, someone, they know they can't do it anymore, the spouse can't do it, the parent can't do it, so they think, okay, I'm secure, I have a POA, they give it to me, I look, the general powers are the only ones that were given, and they're trying to do a special trust, a Medicaid asset protection trust, or something special. We can't do that, okay? So that's the other scenario that we want to make sure we're aware of in talking to professionals, not only just having the form, but am I giving the right powers? The last one I want to talk about, and this is even more concerning, if Don did have a stroke, but he did the power of attorney and he did it right. He had the general powers, he had the specific powers, and he was, gave everything he needed to do, the gifting, the trust, the, beneficiary designations. Sometimes we have an issue with the financial institutions. They're very concerned about being sued. So they start acting in a manner that's overprotective sometimes if that power of attorney is, according to them, stale, is old in their views. If you come with a power of attorney from 2018, 5 years ago, they might think to themselves, how do I know this person didn't execute a different POA in that meantime? So they sometimes unnecessarily reject the power of attorney, even though it appears on its face to be valid. They like people to use their own forms. So I think by rejecting these forms, they're trying to force people to come into the financial institution or the bank and use their own form to give them some comfort. But the problem is when they do this kind of rejection, it's at a point where the power of attorney is obviously needed. So now what does the person do? They then have to either go to court and get a conservatorship, or sometimes maybe online, there might be a way they can do a workaround, but it's a problem that needs to be addressed. The uniform powers form is supposed to have the ability to force the institution to take it if you go through some procedures, but it also gives them an out that if they have some kind of reasonable expectation, or if you're talking about the elderly population, they're worried about there's some potential for financial exploitation, they can use that as an excuse. So there's really no teeth to this protection of forcing a power of attorney on them that's on the books. So I just want to make people aware that this might be the form that while you're still in your right capacity, you may want to keep refreshing new versions of it. Even if you keep the same people in the same powers, just might want to make it on a more regular basis, maybe every 2 years, 3 years. Okay. So I'm going to stop there for a second in case there are any questions before we start getting into the meat of the elder law area.
No questions in the chat right now, but we'll give everyone a second. If you have a question, you can go ahead and put it in the chat. Okay, go ahead, Mr. Miles.
Thank you. So we have really 12 overall areas of elder law, and I'm kind of defining these areas just so you're aware that a lot of states don't certify practice areas. Some do, special states do it in certain areas. The American Bar Association works with National Elder Law Foundation, and they kind of do a certification called the Certified Elder Lawyer. So the Certified Elder Law exam, and that certification kind of outlines 12 points of elder law. And I want to kind of talk to you about what that is and how it all fits into the main estate planning that you might be doing and other things that might pop up that affect you. Kind of gave a little bit, I want to go through all of them, but just point out something. Number 2, the pre-mortem legal planning, that's really the what people would think of as estate planning, your wills, trust, through a power of attorney, the basic taxation issues, fiduciary representation, that's going to be the guardianship, conservatorship. I mentioned if that power of attorney is not accepted and you have to go to court. Also, if you see executive personal representative in this context, I've had this happen. Someone goes through probate, they didn't leave something properly. There was a child with on a public benefit that would be lost if that inheritance came through. So then the representative wanted to petition the court to create a first party special needs trust. So that kind of issue would come up. So we want to talk to people as they're making their wills to understand that sometimes it's not best to just pull something off the net or do something simple, because they have to have certain provisions that might create a supplemental needs trust or a minor trust to make it easier for that beneficiary to receive the property. The health and personal care planning, that we can get into those medical life sustaining issues. You might heard the term living will. We'll kind of talk about that. Legal capacity counseling, there's different levels of capacity. So when you're talking about estate planning, and we'll talk about the different levels, we're concerned when someone comes to our office and they're older and there's another family member who appears to be driving the conversation, maybe even made the appointment, and they're saying, well, I'm being helpful because mom and dad can't do it. We're very sensitive to capacity because this is an area with elderly that we see a high incidence of abuse. And abuse doesn't mean, I'm not talking about physical, I'm talking about financial abuse. Someone gets power of attorney, someone becomes trustee, and then they are siphoning off funds. So we're very concerned about how that process works for making an appointment and who's in the meeting. So if you deal with an attorney and they try to say they're going to meet with that person who's the client first, maybe the parent first, don't necessarily be offended. It's not a personal slight at you. We're trying to have some kind of ethical approach to make sure we're looking out for that person's best interest. Public benefits, that's important. Talk about these life costs, long-term costs. Like I mentioned, a lot of people go to the estate planning, say, I want to get my will, my trust. They feel good. They put it in the binder or safe deposit box or wherever they keep their documents, and they think, okay, I've done that part, check it off. Well, if you don't handle your public benefits qualifications and the ability to have flexibility to qualify, if you have a disability or some long-term care costs, these costs right now for long-term care are running approximately $90,000 a year if you go into certain facilities in certain areas. So you can drain your life savings because that area wasn't addressed properly. So when you pass away, you might have originally thought you were leaving $1 million, and you might be leaving 150,000 because you had to drain those resources. So we want to make sure we talk about these things. The special needs counseling, that is for qualification for benefits, especially if someone has a means-based benefit like SSI or Medicaid, they can't have more than a certain amount of assets. So we have to draft the trust in a certain special way. You can't use regular trust that you would use for avoiding probate. So we have to have certain things that are drafted a certain way to help qualify them. So I said estate planning and I said elder law, and I want you to understand a lot of times they're using the same tools, but they're just using a different way or different emphasis. Estate planner, obviously will, people are familiar with that. I want to make sure I point things out as I go along. Sometimes people think a will avoids probate. I can't tell you how many times people come in, I need a will so I can avoid probate. It's the exact opposite. A will guarantees probate. To probate means to prove the will. So if you have a will, you mandate going through probate. Don't want to talk about the probate system too much, but basically you're going to have to go with a court supervised process, place an ad in the, get up letters, place added in the paper, wait a few months for creditor claims, pay off the creditors. Then at that point, only then can you then distribute according to the will. Trust, people talk about wills versus trust, and we're going to talk about them, but a trust can be contained underneath a will. And that might be a situation, especially if you have a minor beneficiary or some incapacitated beneficiary, would be a good thing to have that trust in there. Revocable trust, a lot of people are familiar with. A lot of times when people come and say, I heard about trust and I want to trust, they're usually talking about the revocable trust. It allows you to be the trustee initially, allows you to be the beneficiary initially. You can revoke it, amend it, and once you pass away, you have terms in that trust that will outline how the property will be held and distributed, who will manage it. And if you do it correctly and have the titling correctly, you can often avoid probate. Irrevocable trusts, those trusts are going to be in the estate planning context, a lot of times where you're dealing with people with a little bit more resources, more wealth, and they have the ability to start doing estate and gift tax, generation skipping tax planning. So a lot of times people come to the office, they say, I've heard about irrevocable trust, but when we start talking to them about it, they don't have the ability to qualify where you can kind of put stuff over to the side, not touch it, and then have enough that you keep in your possession that you can live off of. That's a very hard thing for people to do. So a lot of times we wind up having revocable trust and maybe some kind of business entity for the asset protection, but we can't do the full irrevocable trust approach. But if you can, it's a powerful tool. Joint tenancy, we want to make sure people understand ownership. So just like we talked about the beneficiary designation, passing directly according to the form. Joint tenancy, you own property with someone. You have people who own property sometimes with a parent or a sibling, and I have to point out to them, your will won't control that unless you're the survivor. So we want to make sure people understand titling. It's very important. It's effective to avoid probate, but also can be the flip side, especially in blended families. If I have a second marriage and I do a joint tenant with that spouse, if I pass away, they may take that property and my children who aren't their children may not benefit from that. And we already mentioned the beneficiary designations and how they work and that they avoid the probate process. So that's the estate planner's tool, a lot of death-focused items. Of course, the elder lawyer, we're gonna have life-focused items. We talked about durable power of attorney, advanced directives, your health care. So that one, in some states, they have separate forms. So there's a healthcare power of attorney form where you're just appointing someone to be your agent. There's a living will form where you're stating your preference. Georgia, we combine it together. You can't do separate forms now. So you do an advanced directive. One section is the agent. Second section is going to be your treatment preferences. Third section is going to be appointed guardian. And then the last section is going to do the signatures. HIPAA, you have an advanced directive where you actually name agents to make decisions for you. HIPAA is just who can actually get information about you, so, or medical records. So that form is also helpful while you're live, of course. Revocable trust, we don't use these as much for the person who's trying to get on the benefit, because revocable trust, because you can access it and revoke it and amend it, is considered available to you. So we are using irrevocable trust a lot of times in the elder law field, because we're trying to shield someone from having assets considered available to them. If we're using revocable trust in the elder law area, we're usually using it for a third party, and we'll talk about what that means, where someone besides the person who is trying to get on the benefit is leaving them funds. And of course, joint tenancy, again, we have the ability to have things move. Sometimes if something's 100% yours, if I have a house and I try to go on Medicaid, it's exempt if that first house that I'm living in and the second one is not. So sometimes we have a technique where we can put something in a joint tenancy, add somebody, not through a gift. So make sure I'm clear. If I have 100,000 and I put someone else's name on the property, just to have a joint tenant, I've actually made a gift. I made a $50,000 gift. That can cause a penalty. But if I go 50 on something and they go 50 on something and we buy something for the 100, now I have a 50% owner, it makes it harder for Medicaid to reach it, because now there's some other owner that's part of that property. So those are the kind of techniques we start thinking about doing. I'm going to stop there for a second, just in case there's any other questions before in that section.
No questions yet.
Okay. So as you can imagine, our main concern while someone is on the elder law spectrum is capacity. When does someone lose capacity? How do we deal with that? Everyone, well, not everyone, but a lot of people have optimism that even when I talk to them in their 60s, 75, a lot of times they're saying, well, I'm in pretty good health so far, you know, and it's that can change quickly. So we always want to look ahead as we're talking to clients. The three areas, health and personal care planning, legal capacity, fiduciary representation, they're kind of weaved in together. That capacity needed to sign a legal document depends on what kind of document it is. Testamentary capacity, the ability to make a will, that's the pretty much the lowest level. You just have to have a sense of the nature of your property and who your children are. You know, if I ask you how many kids you have and you say 3 and you really have 3 and you know who they are and you say, I want everyone to have everything, even if you don't know all the details, pretty comfortable with that. But if you're trying to make a trust is more like into a contract. Contractual capacity is more than just some transient state. So sometimes, especially with elderly people, they have good days and bad days, right? Or you might catch them in a good time of the day, or you know that time of the day they're not doing as well. So it may be their capacity might vary during certain stages. We are much more concerned about doing a trust for someone who has that in and out. Okay, so we'll look at that a little differently. Durable power of attorney also, since it's financial, we're a lot more concerned about that than testamentary, which is after you pass away. We have in Georgia an intestate, well, every state has an intestate statute. If you don't have a will, you're often going to have to go through the intestate statute, which says this is where your property will go based on relations that are usually natural or adopted. So if you have stepchildren, they won't be included. So we have, with testamentary capacity, we want to kind of give someone the ability to avoid that intestate situation, but doing other things with contracts and trust and durable power attorneys, we're raising the bar a little bit on when they can do these things. So that's part of the reason why when someone comes to the office and makes a call and says, I'm making this appointment for my mother, it's an automatic, in the sense, red flag, okay? Because now we're just on alert, because we need to now pay attention, okay? Why didn't this person make this appointment themselves? I'm gonna meet with them by themselves, get an assessment for myself of what I think their capacity is as an attorney. There are certain tests that are out there. We don't try to administer them as an attorney. We don't have that kind of training, but we do have a sense of our ethical comfort level. Okay? Now, we talked about in the beginning, if Don had that stroke, he didn't get a chance to make a power of attorney. Now someone actually needs to do something for him. We often have to turn to the court. Guardianships, conservatorship. Guardianship is over the person. That is your medical decision-making, where that person lives. That's going to be done in the advance directive. We can nominate that person there. The durable power of attorney is going to be conservators over finances. You can have the same person be appointed. You might have separate people be appointed. You might have a limited appointment for certain matters, especially conservatorship. Maybe I want to have you manage a little bit of the money, or guardianship only make certain decisions, or I can give you plenary and just let you have complete authority over someone else. The durable power attorney, you can make a nomination there for conservator. We try to at least have the forms have the nomination, because if you don't have the nomination on your form, you lose the priority that's in the statute, and then it's much more open to whoever can be the court-appointed person. So we definitely want to make sure to pay attention to those items. Always want to point out too, even if we go through this process, you get a power of attorney, whether from an attorney, do it yourself, you have it, notarized. That power of attorney is not going to be accepted by Social Security Administration. They have their own program, representative payee program. Veterans Affairs, not going to be accepted there. They have their own fiduciary program. Those agencies want to have their own methods of appointing people to receive funds for their individuals. So I just want to make sure that's clear. So don't think, again, I'm going to get this form, check it off, put it in the binder, put it in the safe, I'm good. You still have some steps you may need to take depending on what that person's income is. Okay. Now we're getting to the pre-mortem legal planning. I'm going to start talking about the difference between wills and trusts a little bit. So I'm going to stop here and see if there's any questions before we go further.
Nothing in the chat.
Okay. So you see here, giving, preparing documents, wills, trusts, durable power of attorneys, gifting issues, taxes. Again, now we have the full spectrum. The estate planner can have all these different tools. I look at them as tools. They're not good, they're not bad. It's situational. What works for whatever situation, you reach in, you pull it, you use it. So there's not one thing that's better than the other. Some people say, well, don't have wills. Sometimes you do want a will. Why? Because say you're a single parent, you move to a new area, you don't have anybody that you're necessarily comfortable with having as a trustee of your trust that you set up. You might want to have it actually go into conservatorship and just say, I want to have a will that purposely goes into conservatorship so that I know that the court is watching somebody, okay? Just tools and techniques. Wills versus trusts. Okay. Most people know wills go through probate. They talk about trust avoiding probate. Wills are public. Okay. Trusts are private. A lot of times, especially when celebrities pass away, then you see some article come, this is what happened with so-and-so, the state and this and that. Well, that's what went through their probate estate, but they may have had stuff directly passed from beneficiary designation. They may have had stuff in trust, but the public portion, the wills, is what gets all the attention. And that's part of the reason why we don't want to have those wills if we can avoid it. If we do a will with a trust, we'll do what's called a pour over will. We'll basically have a will that says, if I did not get a chance to put something into my estate, my trust while I'm alive, take my probate estate and put it into that trust. That's all that will say. So someone who reads it doesn't know who the beneficiaries are. That beneficiary detail is sitting over there in that trust. That's the privacy. Less time to create for a will, for the most part. There's always assumption of how complicated a will could be depending on what you're doing. But more time consuming, generally trust is going to be more time consuming. Wills effective on death. Trusts give us some incapacity management. What does that mean? If I create a trust and I have a bank account that I retitle into the trust and I become incapacitated, a lot of times we're cutting down on that issue with the financial institutions rejecting. All right, so if I have a POA and my POA is stale, that financial institution might reject it. If I move that bank account into the trust when I first set it up, if I 5 years later become incapacitated and there's a trustee in the document that takes over next, they usually do not have any problem because the banks and financial institutions respect that trust function. Takes up to 1 to 2 years, that's a general statement, but it does take a while for a will. Trust, because it operates outside the court system, you don't have that lead-in of everything going on with trying to go through the court procedures. That's especially important if you're leaving something to an incapacitated beneficiary. They may need the funds, but you can't fund it if you leave it through the will portion and have the testamentary trust, because the testamentary trust still has to go through the probate process first before that testamentary trust is funded. Less expensive, that's really what it comes down to a lot of times. We are practical. Trusts are a lot more expensive. And sometimes people just decide that they don't want to put that expense towards that particular thing. They want to say, well, maybe I could start with the will and then later, move up. But of course, the counter argument to that is the reason why you're doing the estate planning in the first place is the uncertainty of life happening to you, or more importantly, maybe sometimes death or incapacity happening to you. So we don't really like to say, start with the simple and plan to step up later, because you may not get that chance. Jump down a little bit. Assets are frozen upon death with wills. Probate property is going to be an item that's in your individual name that doesn't have a means to pass by another method. So if I have the house that I'm a joint tenant with, when I pass, my interest moves by the deed. If I have a bank account, it moves to the other person. If I have an IRA, the beneficiary form moves it to another person. But if I have a bank account that only in my name with no payable on death designation, that account gets frozen, okay? If it's in the trust name and I pass away, the trust document just says, okay, here's the next beneficiary up. Here's a trustee that's gonna manage. The asset is not frozen because the trust is still in effect. There's no stoppage there. And a big one that people underestimate is the last one. Wills, even though they're trying to usually not be bothered with contest, there's nothing that you can do. You can put some clause in there that says someone who contests my will lose their share. It doesn't stop someone from contesting your will. And actually, the way that's usually written, people try not to leave they'll put a terror clause in there, say, if you contest this will, you get nothing, which really gives them incentive, because if I accept what you're giving me, which is probably nothing, or if I challenge and get nothing, I'm in the same spot. So a lot of times people, if they're not happy with whatever they were given, they have an incentive to probably contest it, because if it gets thrown out, then the will goes back to the intestate, not the will, the distribution goes back to the intestate statute. That might give them a minimum share that's a lot higher than what you were giving them under the will. Trusts are a lot harder to contest. Okay? You have because you made it while you're alive, some of those things that you can challenge on in a will, someone didn't have capacity, someone was unduly influenced. That's much harder to talk about with a trust. Okay, so wills are definitely easier, but there's a lot more risk to them. Trying to move forward again. Okay. Public benefits. This is the area that sometimes we get some confusion on. I talk to people and I can hear that they're not quite clear one benefit from the other. So I kind of want to walk through this and make sure we're clear today. Social Security. When people talk about Social Security, a lot of times in their head, they're thinking about retirement. Social Security retirement that you can potentially start taking at 62. Your retirement age now, depending on how old you are, probably going to be 67, your full retirement age. If you keep going beyond that to 70, you can hold off and get a little bigger benefit. That's retirement income. What we're talking about a lot of times where we're worried about someone not being able to work or needing some health benefits, we're talking about the disability income portion of Social Security. Okay. The income for survivors and dependents, that's if someone who was in the system, who had retirement, maybe they passed away and then their survivor, spouse, dependent can take their share and get their money. But really that middle part, that disability, that's what I want to focus on. There's two disability areas, and this is important to understand because they're linked to different programs. Social Security disability, these are people who have worked at some point, had a work history. Now they are unable to work. Now there's a statutory definition of disability, a time period, 12 months, you can't have substantial gainful activity, which is based on the amount of money you make. So to be clear, so if I were, say, blind and I was an actor who had a movie role and that movie role paid me money, Social Security disability would say you're not disabled because you were able to earn a certain amount of money. Okay, so I want to be clear how they look at the world. That Social Security disability insurance is linked to Medicare. Okay, Medicare, we'll talk about that, is really your hospital insurance, your supplemental security income. That is going to be for people with limited resources, limited income, limited assets. You don't need a work history. We're focused on what your financial need is. If you get Social Security, supplemental security income in the state of Georgia, you automatically get Medicaid that day. So it's very important for those people with limited means to get SSI because it always pulls in Medicaid, which is their health. Social Security disability after 24 months will give you eventually Medicare, but there's a gap between getting disability approval and then still getting Medicare. Quickly, Medicare has 4 parts. Medicare is federal. Okay, if I'm in California, Texas, New York, Florida, Medicare system is the exact same. Part A, hospital. The issue with Part A, a lot of the benefits that come with skilled nursing and other things require a 3-day stay. You may have heard sometimes when you're going to the hospital, even though you're actually in the hospital, they haven't formally quote unquote, admitted you to the hospital. So you could be sitting in a room, but not admitted. You're under what they call under observation. And at that point, we have issues with people having to come out of pocket later. The other things, A and B is what we call original Medicare. C, they kind of try to cut costs and have HMO type policies. Here, like Aetna and other insurers that do Medicare Advantage. And Part D is your prescription. Medicaid, want to point out really is state by state. The issue we find as lawyers, people don't understand that if you move someone, especially if family members are trying to figure out where does mom or dad go? Do they stay in Georgia? Do they move up to, North Carolina? Do they go up to New Jersey? Each state has its own Medicaid program. If you move, you do not automatically just shift into the new state's program. You have to apply. And that is where we potentially have some issues where people try to go from state to state and the qualifications are different or the amount that they can keep under that system is different. And that can have dramatic differences for them financially. Your durable power of attorney is important. I mentioned that special powers that you have, creating a trust. We're going to create an irrevocable trust. So sometimes we might need to create a special needs trust for somebody. We don't have the ability to do that unless those durable power of attorneys are giving the proper powers. So don't look at them as a very basic document. That durable power of attorney is incredibly important and has applications for people that financially can be devastating if they don't have those powers given. Special needs trust. The different types of special needs trusts, want to make sure we understand the basic two. First party. This is the assets of the person trying to get the benefit. If I'm on Medicaid, I have a personal injury settlement, those settlement funds are mine. They will lose my benefit if they're considered to, assessed to me. I have to create a trust that's written in a certain way, must be irrevocable, that will take those funds, put it in there, be written in such a way that the agency will review it. They review all the trusts, they look through it line by line, and if they agree that it's okay, they will then bless you to have those funds. The key part about that is that the last thing here, must refund state Medicaid upon the beneficiary's death. So once you get on Medicaid with a first party trust, they will then keep a tab on what they spend on you. When you pass away, they will go to your trustee and say, we spent this much. Give us what we can get out of this trust. If they don't get everything out of that trust, that's when you hear about going against the probate estate, that Medicaid estate recovery. The third party trust is established by a donor who is anybody but the person who's on the benefit. Parent, spouse, the uncle, grandparent, friend. Those funds are coming from someone else. No age limit, okay? You have to be 65 to create a first party trust. That's part of the reason why we have other issues with elderly. They're beyond that first party trust stage. Then you might have heard Medicaid asset protection trust you have to do, or some other special strategies, because that first party trust is not available to them. Third party is not a problem. I could be 100-year-old parent leaving a third party trust to my 75-year-old son. If I do it properly, it won't be a problem because there's no age limit on a third party trust. And there is no payback, okay? First party, if I'm using my funds for my personal injury settlement or my inheritance, I got to put in the first party trust, pay back Medicaid. If it's a third party trust that someone else created for me, Medicaid can run up all the bill they want to. When I pass, whoever made that trust can have provisions in there. After Keith passes, it goes to my other children. Medicaid does not have to be paid back. So it's absolutely crucial to do these trusts right, to know what the difference is, because this could be financially a generational wealth difference between being able to leave things to the rest of the family or not. So again, durable power of attorney, if we don't have it set up properly before it happens. So say a parent had a situation where I'd had my children's name directly on a form. I then have a stroke. Someone who's my agent realizes, oh, there's a child here who would lose their benefit because the parent had their name on the form. We need to have the durable power of attorney, number one, with the ability to change the form over to a special needs trust and the ability to create the special needs trust to put those funds in. So this is absolutely critical to have that power of attorney, to have the ability to create not only revocable trust, but irrevocable trust. Irrevocable for the first party, revocable third party. Quickly to the non-core areas. Life insurance. People are familiar with life insurance. The main difference, term, permanent. Term will have a term. Most people, 98%, I believe, usually outlive the term. So when we're doing estate planning, we're trying to lean more towards the permanent because it's going to be guaranteed in force as long as you keep the premium. So when we're trying to have any kind of fund that we're creating for beneficiaries, we're worried that if we have term insurance and we live beyond that point in time, that the estate plan won't be able to fund the generational wealth like we plan to. Term insurance, especially if you're young with kids, definitely appreciate the fact that you want to have that coverage. It's affordable. But if we start to get a little bit midlife and later, now we need to probably switch over to some kind of permanent policy and shift that in our plan. If we have long-term care insurance, long-term care insurance is harder to get nowadays. The insurers are leaving the industry, but what it's doing is filling a gap where someone may be able to have long-term care insurance pay for their expenses without going on Medicaid, which has these onerous asset limits. You have to have help to trigger the policy in certain areas: dressing, eating, bathing, transferring, getting up, from bed and moving around, continence, toileting. These things are usually have to have two areas that you need help with before the policy gets triggered. 70% of the population that's elderly usually has a need for long-term care at some point. So we are not really planning enough for something that's going to happen 70% of the time. Okay? We need to also understand that with long-term care insurance, a lot of times what happens, if you have a traditional policy, it's what's called a partnership policy. Whatever, say I have a $300,000 long-term care insurance that I use, it will pay as I go through the terms of the deal. It might just give me reimbursement payments. I put the money out for a home aid. I submit it to the insurance company. They reimburse me. Once I get through $300,000, I've used up that policy. But now Medicaid rewards me with allowing me to have more assets that I can shield. So if I use a $300,000 long-term care insurance policy, ordinarily when I went on Medicare, I could only have $2,000. Now I can have up to $302,000 I protect. So now I can potentially protect my home because I use my long-term care policy to up that limit of what I could protect. And lastly, reverse mortgages. Sometimes people hear reverse mortgages and they cringe and they say this is a bad deal all the time. We use this with elder law with someone, especially if they are a senior who's trying to stay at home. They are really, you heard the phrase, you're cash poor, house rich, right? You don't have enough to spend on expenses. How are you going to get money in your hand to do that, get that cash flow? This is a situation where reverse mortgage is used often, especially if the senior person is not worried about leaving the house to someone. Like I said, maybe they're single, maybe they don't have children. They just want to make sure that they have a source of income to keep them in the house as long as possible. So reverse mortgages, you have to be at least 62, but it could be a great tool for having the ability to keep yourself in the home without having to go on Medicaid. And then while you're getting these payments, then you can do those things like the Medicaid Asset Protection Trust and other things to shield some money, because you can ride out that 5-year waiting period while you have this income coming in. So we just have a lot of different options of things to do. So we just hope that we don't just get a narrow vision of, okay, estate planning is just about death and taxes. We want to make sure sequentially we think about taking care of everything in life, planning for our health, planning for our long-term care. And if we do that correctly, we will have more left later. Do any Q&A?
There's none in the chat, but I do have a question. So I'm going to go ahead and hopefully this will warm up those that are on the phone. You mentioned the difference in cost between executing a will versus a trust. How big of a difference is there
Okay,
in that cost?
good question. And prices are always going to be uh, dependent on that attorney and price, different regional areas, right?
Mhm.
But I would say as someone who practices estate planning, not so, that's the other part of it. There's people who don't practice estate planning as their main area, but they may do, wills as part of another practice area adjacent to what they do. So their prices may be lower. So I'm gonna give you an idea from someone I think of the people I know who do this area as most of their practice. A will probably run you even at the lower end. I would say $1,000 to $1,500, depending on what and I say will with a package of advance directive, power of attorney, they're doing all the full planning or that thing. That would be the lower end. The trust depends on some people's comfort level of pricing, but I wouldn't imagine someone's going under 3,500, but I could see someone starting at 5,000 for a basic trust. And then a basic trust meaning I'm just having a trust that pushes funds outright to the beneficiaries. I'm not doing any kind of special distribution planning where I'm saying hold till 25, 30, and 35, and or conditional on getting, a degree at some point where I'm doing a little something more complicated, and certainly not anything where you're putting in kind of a state tax provisions in there. So state tax provisions, you're probably going to be 10,000 plus. So it depends on the particular provisions within the trust, but the trust generally will be, I would be surprised if you found one for less than 3,500.
Okay. So it wasn't Warren Buffett price, but
well, that's for most. The prices I'm giving you are going to be flat fee for the most part, the middle class, volume client that's coming through the office.
okay.
The larger, ultra wealthy, they're probably that's a whole different set, right? That's going to be the large law firm. They got an army of lawyers probably billing by the hour. So that's a different business model.
Got it. Thank you.
You're welcome.
We don't have a question, but we do have a comment from Carla Zachary saying that this is very helpful information.
Thank you, Carla.
We have Maria White. Maria, do you want me to read it, or I'll go ahead and read it, and if you want to follow up, Maria, you can feel free to unmute. Maria states that her mother is about to turn 80. She lives in a house I own and drives a car I own. She doesn't have any real assets other than her personal property. Does she need a will? What challenges might we face if she passes away?
Okay. So the first question, does she need a will? I want to start with, okay, just looking at her property now. You may look and say, well, she doesn't really have anything now. A lot of people have a will that actually follows their intestate distribution. So if I had no spouse and 3 kids, the intestate statute says with no spouse and 3 kids, each child gets 1/3, 1/3, 1/3. Well, that might be very well what my will does, right? So my will is really just naming my executor. I don't have any minor kids if I'm 80, presumably. And she doesn't have assets. Really, you're just naming the executor with the will because it's going to have the same distribution pattern. But the will also protects against receiving estate property that you didn't anticipate, right? So right now, she doesn't have anything. But say the caller, whoever posed the question, say you pass away and somehow that property wound up going to her, we might want to have some will in there that just says, okay, if this property comes back to her and it has to then go to someone else who might be a sibling of hers, and they may be on a situation where they're on a public benefit Medicaid or something that we will blow their benefits. It's more of a fail-safe fallback protection. So even if someone doesn't have much, so to speak, we just want to outline especially if they have provisions for incapacitated beneficiaries in their will, minor beneficiaries, if something comes to them and it winds up going to a grandchild, we still just want to have a will in place just in case. But there's no reason to, spend, thousands and thousands of dollars to come up with a complicated will, but you definitely want to probably just have something.
The next question we have, so what should I do now at 61? I have no will, 5 children, no husband.
Okay. Well, the first question, you said 5 children. The first question I would ask them is, what are the ages? And then, are there any children who are incapacitated? If not, are there any children that you worry about them managing money, right?
Mhm.
Because even though someone might be an adult, that doesn't mean we feel comfortable with them getting money at a certain point. So that's the first question.
The children are 27 through 40.
Okay. And if we're comfortable with them getting money, a lot of times when I usually ask for background intake while I have all the assets out there, and I'll talk to them about making a decision. Okay, if they had minor children, we're talking about doing a trust to have that in management for them. If they're adult children like that, 27 through 40, now we're just making sure, okay, let's just coordinate beneficiary designations, make sure everybody's name is on a form somewhere. We don't want something to not have a designation and fall into probate. So it's just coordinating a lot of times beneficiary designation forms, percentages, making sure everybody's okay. If you do a will, that's when we want to make sure we have provisions. Okay, I'm going to leave, presumably 1/5 to every child. Some children may not have children, others do. How do we address that? If that child who doesn't have children passes away, do we have that share go amongst the other ones pro rata? Do we have it go someplace else? So just that would be the control part of just outlining where everything goes. I have a lot of situations, for some reason, more recently than I have in the past, where parents are coming to disinherit a particular child. So they may have 5 and one of them, they don't want to have something. That you can only do in a will. You can't do that because if you don't have will, because the intestate statute is just going to automatically go by bloodline and just pass out to a child regardless of your relationship. So if there's any kind of special situation, or you want to add in a beneficiary, okay, I have 5 natural children, but I have a stepchild that I want to treat like my natural child, you can only do that with a will. So once you kind of talk to the person, sometimes there might be some little thing that goes into that. Also, specific requests. I have 5 children. That doesn't mean I want all 5 of them to share property 1/5 each. There might be, say I have 3 houses, I might want a house or 2 to go to a specific child. I do a specific request in the will, pull it out first, and then the residue is what's going to pass 1/5 each. So if you have any kind of thing that varies from that default equal distribution, you'll need a will.
Okay, next question I have is, sorry, got to scroll back up. Can you speak about the difference between an advance directive and a medical power of attorney?
Okay, well, a difference is an advance directive in Georgia is a combined form that contains that medical power of attorney inside of it. So in other states, you would literally have 2 different forms. You would have a medical power of attorney where someone is saying, this form is just for appointing an agent. And then you have another form, which is called living will, which people get confused a lot of times with last will and testament. But a living will where you're just saying, this is how I want my life to be either extended or not extended. Georgia did not, at one point in time, had separate forms. In 2007, we adopted an advance directive where we slapped them together. So the advance directive handles the appointing an agent like a medical power of attorney. It also handles the treatment preferences like the living will, but it does it in one standard document. And we can't execute separate forms in the state of Georgia anymore. We have to do the advance directive for healthcare.
Okay. I see we have one hand raised. Tracy, you can go ahead and unmute and ask your question.
Thank you. So For all these different forms and plans and everything that you're mentioning, is it better to have an attorney to go over these with, or is it something you can do yourself?
I would never recommend, as an attorney, I'm never going to recommend someone do this area by yourself, particularly as an elder law attorney, because we're going to talk about issues of capacity, like I mentioned with the durable power of attorney. That's why I started with those examples. Many people do it themselves because, especially with a durable power of attorney, you can usually pull that off the internet and feel, okay, all I have to do is fill out a few boxes. But for example, the special powers I mentioned, if someone wanted to create a trust, for example, you need to have not only the ability to create a trust. If you look on the form, it says gifting. Now, gifting by default, when you look at the form, it may not be clear. What it means when that uniform form is that you're limited on gifts to what the gift tax annual exclusion amount, which is for 2023, $17,000. So if I wanted to do a Medicaid asset protection trust, someone comes to my office and say, okay, I wanted, I have $1 million. I'm going to try to put my house and, $300,000 of cash into this Medicaid asset protection trust, write it out the 5 years, use the money I kept outside of the trust to, in case I have any expenses. And then once we're past the 5 years, we've protected the stuff that's inside the trust. I can't move stuff for them if they become incapacitated, if their power of attorney doesn't have beyond the regular default gifting powers, because the default that you check on there that you see only gives you 17,000. We have to, as attorney, draft special provisions that say, no, we're trying to do unlimited gifting. We're trying to do Medicaid planning. We're trying to do special needs trust. We can't move a $400,000 house if the gifting provision that we have defaults only to 17,000. So that's what happens a lot of times when people come to the office. They have power of attorneys, but the power of attorneys aren't sufficient to do the particular type of planning, especially on the elder law side, that we need to do.
Thank you.
You're welcome. Good question.
The next question I have is, how many copies of the will do you need and where will it be housed?
Okay. Copies aren't, when you're doing I do a set of estate planning documents, power of attorney, advance directive, HIPAA, will, trust. All of these documents, you can use a copy like an original, except for the will. The court wants the original will, okay? So a copy of it, if you try to put it in for petition, you're gonna have a problem with the judge. Judge will say, hey, where's the original? There may be some issues of trying to get that will actually accepted. So with a will, I always have people just make copies of the signed documents, because I have a client portal. I just want to have the signed documents on the portal, just in case those are lost. We want to just have some kind of proof of what the document said at a particular point in time. The other documents, power of attorney, we can use a copy, just like an original. Advance directive, use like a copy like original. The trust, we can use a copy like original, but you can't do that for the will. So I want to just distinguish that. Now, the other ones, you can have as many copies as you want. I don't recommend having a lot of copies of the durable power of attorney. Why? It's a little bit different than the other form. The advance directive is your health form. We can spread that all over the place, right? I can give that to the doctor. I give that to my agents. I give that to other family members. I want people to know what my choices are, because that form is only used when you are not able to give your input. The durable power of attorney for finances is not the same way. Durable power of attorney, basically you are replicating yourself when you give someone that power. So if I give my agent on Wednesday a durable power of attorney and say, hey, I made you my agent. If I had an unscrupulous agent, they can go to the bank on Friday and withdraw from my account. They have the same power I do. I don't have to be incapacitated for that power to work. It just continues after I am incapacitated. So it's not quite the same. We don't give out the durable power of attorney as freely as we give out the other forms.
Okay, and how does a potential client start to work with you?
Well, it depends on how they come to me. Some people come because they're coming from a referral source, a financial advisor, another attorney, accountant. I remember legal plans, so some people come from Legal Shield, there's a MetLife. Some people are just finding me through Google search, but when you get to my process, I have people make their appointment right through my website because I don't want to try to coordinate schedules. And so the good part about that is you can go on 24/7, see what my calendar is, and then you can make your appointment. The bad part is you got to get in there fast because the slot you want, if you wait, someone else comes along, might take it, right? So I find it easier sometimes. The clients, that some people just like a personal touch. So I do have, assistant that will just call someone if they ask to have somebody walk them through the process. So we could do it that way too. But either way, the assistant's still using the same online scheduler.
And is that the estateplan.esq.com?
Yes, ma'am.
Okay, I will put that in the chat for everyone to have along
I'm gonna
with.
move here. It's right here on my.
There we go.
And it's right when you come to the home page, you'll see a little schedule an appointment icon. And I give free consultations for new clients. If you come from, sorority and say that you came through this, I usually give a 25% discount off of the price schedule.
Okay, I don't see any additional questions or raised hands. And I'm going to share the link to the slides for this evening in the chat as well.
Okay, thank you.
All right. Thank you so much. As you have seen, the messages in the chat saying this is very, very informative. This was a wealth of information, and this was very, very wonderful. And we are so grateful that you have been able to provide this information to us this evening. Learning a lot about durable power of attorneys, the difference between getting a will versus a trust, and then the irrevocable versus the revocable trust. And then I'm glad you mentioned about the life insurance, because that's very important, about the term life versus the permanent life insurance or whole life insurance, and the difference between Medicare and Medicaid. So I hope everyone was able to take something away from tonight and, to be able to think about, okay, what's my next step as far as my estate plan? Me, myself, of course, coming from estate planning law firm as well, I already have my estate plan. So I wanted to set the example for my family to go ahead and start their estate plan. And I'm glad that they were able to join this evening. And thank you to everyone that was able to join this evening. We wanted to, of course, make sure that we said thank you in a very special way, which we have. And once we get off this call, you will see what we sent to you to say thank you so much. We wanted to appreciate you and provide a token of our appreciation. And we have, and you will see once we leave the call, what we sent to you for to say thank you. And our president, she actually had something else that she was working on this evening. So I'm glad you had an opportunity to meet her, who is also an attorney, President Michelle Langham Robinson, Esquire. So I'm glad you had that opportunity. But our closing remarks this evening will be given by our first Vice President, Lydia Thacker. And I yield the floor to you.
Okay, and that would be, first Vice President would be Cindy, who is prepared to give remarks. But I want to thank you for somebody who is recently retired and then took care of a mother-in-law after a stroke. This information is vital for everyone. We thank you.
I
First.
I sincerely apologize. I was looking at your face and talking at the same time. I'm so sorry. The first
Okay.
Vice President, we do yield the floor to you, Ms. Gibbons.
No problem, Alexis. I was okay with that. And you pretty much stole my thunder because I actually took notes. But first and foremost, I want to thank you, Attorney Keith Miles. This was great information. And thank you so much for that 25% discount. I will be calling you. So as Alexis mentioned, on behalf of our president, Michelle Langham Robinson Esquire, we're so grateful and thankful that you have joined us this evening. You have given us a lot of information about estate planning. So I'm gonna go ahead and skip what I wanted to speak about the wills and the trust, but I'm glad you touched on reverse mortgages because I've always looked at that as being negative. I just thought, people were taking advantage of the elderly, but you explained it perfectly. So I would definitely be looking into that as well. Again, thank you so much for taking the time out to educate us on estate planning. And I know we'll be contacting you sooner rather than later. And I wish everyone a good night.
Oh,
And
thank you. I just want to say
much.
thank you before you go. It's been a pleasure on my part. It's always an honor to come before you. So I'm looking forward to maybe doing it again if you have some other time that you want me to come back.
Thank you so much.
All right, everyone. Well, I would like to say good night. And for those of you that are members of Kappa Iota Zeta chapter and the Zeta Amici of East Point, if you would all stay on just for a quick moment, we would like the technology team to quickly get a screenshot of all of us with Attorney Keith Meyer. Good night.
Stay on.
Did they stay on?
I don't know, they're leaving.
Oh,
If you're getting a picture, hurry up.
Alexis, I wanted to say, I did notice that our state director was on. So Ms. McKay.
Thank you, Dr. McCoy. I won't belabor the point, but definitely appreciate my chapter, Kappa Iota Zeta, having a celebration for Violet Anderson, the first African-American woman to argue before the Supreme Court. Quite an honor. And to get this information is outstanding and really appreciate it coming from different aspects. As a married lady with no children, no grandchildren, just wanting to point out that everyone's scenario is different. So thank you again for having this, and thank you to the attorney for presenting so many different aspects.
Thank you so much.
Thank you.